Good morning, everyone. We'll get started in just a few moments. So thanks for joining us for this Life Lessons webinar. Well, I want to welcome everyone and thank you for joining our Life Lessons webinar. My name is Barbara Thomas and I'm with the Tippie College of Business. Now today our webinar is entitled Death is in the Details. This webinar is one of 7 Life Lessons webinars that are designed to provide you with insight and ideas for each stage of your life. We have one more webinar scheduled in this series, which is scheduled on March 1st, and it is actually on the tax implications at each stage of your life. All of our webinars are recorded and shared both on the Tippie College's YouTube page and on our alumni web pages. Several days after our webinar, we will send an email to all those who registered with a link to the video with the transcriptions. Now, I do want to provide a reminder before we begin that these webinars are to provide you with ideas, but we are not providing you with official financial or legal advice. After attending our webinars, we encourage you to discuss these issues with your own lawyer or your own financial planner. So today, during our webinar, you can submit your questions to our speakers through the Q&A button at the bottom of your screen. We'll do our best to answer as many questions as we can. Now, our presentation today will be moderated by Pat Heiden, who spent her professional career advocating for older adults. She retired in 2016 from Oaknoll Retirement Residences after 36 years of service, the last 22 of which as their executive director. After retiring, Pat entered the world of politics and served on the Johnson County Board of Supervisors for a 4-year term ending in December of 2022. She was a licensed nursing home administrator for 30 years and a graduate of the University of Iowa. She has a master's degree in Health Services Administration from St. Joseph College in Windham, Maine. Our first panelist today is Susan Hagan, the Executive Director of Planned Giving at the University of Iowa Center for Advancement. After graduating from the University of Iowa College of Law, Susan practiced estate planning at a Milwaukee law firm for several years before working as a trust officer at what is now U.S. Bank in Iowa City. Susan joined the University of Iowa Center for Advancement in their Planned Giving department in 1999. She has served as its executive director since 2006, helping alumni and friends of the University of Iowa to include the university in their long-range plans. She is joined on the panel today by Bob Michael, a lifelong resident of Iowa City and a big Hawkeye fan, I know that. He received his Bachelor of Science degree in computer science from the University of Iowa in 1984 and a JD with distinction from the University of Iowa College of Law in 1987. He is a partner at Holland, Michael, Raiber Sittig PLC, a general practice law firm in Iowa City. Bob has been practicing law in Iowa City for over 40 years, including extensive work in estate planning. He has also been a guest speaker for several times over the years at Tippie on the topics of estate planning as a part of the financial planning process. And our final panelist today is Michael Lensing, co-owner of Lensing Funeral and Cremation Service and Faithful Companions Pet and Cremation Service, both in the Iowa City area. A native Iowan, Michael graduated from the University of Iowa in 1974. While attending Iowa, he was employed at a local funeral home, and that experience is what changed his life. Michael graduated from the Indiana College of Mortuary Science and has been a certified funeral service practitioner since 1976. He has served on many community boards and committees and enjoys supporting local philanthropies. He believes that rituals, ceremonies, and life celebrations are essential in saying goodbye and healing following a loss. I think those are very accurate thoughts there, Michael. I appreciate that thought. And with that, I will turn this over to Pat Heiden to moderate our discussion. Pat?
Thank you, Barb. And thanks to the Tippie College of Business for organizing this thoughtful series filled with such useful information as we maneuver through different stages of life and the unique challenges of each. From finding our financial footing to building our nest and getting our ducks in a row to how to plan for retirement, here we are at the 6th installment of the series, Death is in the Details. For those of us who have been blessed with the gift of time, we are also faced with thinking about our inevitable deaths. It's something none of us want to talk about, but we owe it to ourselves and our loved ones to do just that. It's so important to have those difficult discussions, making sure legal and financial arrangements are in place and our wishes documented. What a gift to give ourselves and our loved ones. So let's get started. Each of the panelists will have 10 to 12 minutes to address their topic. And then at the end of the presentations, we will answer as many questions as time allows. So with that, I will turn it over to Susan.
Thanks, Pat. Well, as Barb said, my name is Susan Hagan, and I'm the Executive Director of Planned Giving at the University of Iowa Center for Advancement. And I'm going to talk to you today of a few minutes really about some things you might want to consider, whether you are leaving assets to family members or to charity. So you'll see from my first slide, there's really only 3 ways you can direct your estate. You can leave it to family or other individuals. You can leave it to charity, or in some cases, you can leave it to the government. And I'm just going to touch on that last point first. First of all, if you have a very large estate, and by that I mean over $12.92 million for an individual, you may be subject to federal estate tax. If you're in that situation, you definitely want to talk to your estate planning attorney about how to minimize that. I think the statistics show that today less than 0.1% of estates actually pay estate tax anymore, federal estate tax. So it doesn't impact very many people, but if you fall into that situation, it is something that you'll need to talk to your attorney about. Some states also have their own estate or inheritance tax. I think it's fewer than 20 that have one of those anymore, but it's possible that you will live in a state that has one of those and you'll want to talk to your attorney about that as well. One thing about inheritance tax, if you do live in a state that has that, it doesn't necessarily apply to everybody that you might leave assets to. I know in Iowa, we have an inheritance tax. It only applies to certain people that you leave assets to and not others. So even if your state has that, it might not actually impact your situation. Finally, if you die without an estate plan in place, or maybe you have a plan, but you have an asset that somehow doesn't get pulled into the plan, then the laws of your state will determine where those assets go. And every state is a little bit different, but the one thing they have in common is they try to find a way to get it to relatives of yours. But if you died and they could locate no living relatives, then in that case, your assets could go to your state of residence. A few things to think about when leaving assets to family members. First of all, you need to think about whether you want to treat all of your family members equally or allocate based on perceived need. And it's going to be a different situation in every family, but you just want to maybe think about what your family members' needs are and what makes sense in your situation. And I would just say you might want to also talk to your family members about that. You may feel like you need to treat all of your children equally. But if you talk to them, you might find out that the one that's a successful surgeon is okay with giving the one that's a struggling school teacher more from your estate. So just talk to your family about your situation. When you are leaving assets to individuals, one thing you might want to think about is whether or not it makes sense to leave money in trust for an individual rather than have their share go outright to them in a lump sum. Many times it makes sense just to go ahead and distribute assets to these family members. But sometimes there's a family member who, for one reason or another, you don't feel comfortable giving them a lump sum upon your passing. And so you might want to have their assets go in trust for them. In that case, the trustee can manage the assets and can make distributions to them and ensuring that the money is managed properly. One thing to keep in mind about a trust is it doesn't have to be for lifetime. You could have assets go in trust until the person reaches a certain age, or you could have it go in trust for a certain period of years or something. So that's a nice option to consider, and one that you can talk about with your attorney if you feel like it might fit your situation. The third point there I would emphasize is, if it's important to you, put it in writing. Don't rely on somebody's word that they will carry out your wishes. So for example, if you want to make a gift to your church upon your passing, I would put it in writing as part of your estate plan. I would not just leave everything to your kids and ask the kids to make that gift to your church, because they may or may not follow through with your wishes. And while everybody likes to think that their family members will do everything they want them to, that doesn't always work out that way. And so, to be realistic, if you want it to happen, the only way to make sure is to have it in writing. Finally, I would think twice about naming a family member as your executor, or in some cases, in some states, it might be called a personal representative. There's a lot to serving as an executor. There's a lot of court documents that have to be filed. There are accountings to do. There are tax returns to have prepared. And not everybody has the skills or really the inclination or the time to do a good job as serving as an executor. And if you name a family member, they may end up making mistakes. They may mismanage the estate. They may, not pay claims that they should have. There's all kinds of ways that they can do something wrong with your estate. But if you name a professional, and I really mean a bank trust department, they will handle it. That's what they do. So they know what they're doing. They will get everything done efficiently. They won't be making mistakes. They won't be wasting time. And you will just know that it's getting done in the best possible way. I've got a friend that's an estate planning attorney, and he told me that what he tells his clients is, if you've got a problem with your teeth, you go to a dentist, you don't go to your kids. And if you need an executor, you should go to a bank. You don't go to your kids. And I think that is very wise advice. A few things to think about when leaving money to charity. First, of course, is deciding what charities you might want to support. A lot of times people will start with looking at the charities they've supported during their lifetime that have been important to them. But once you have determined what charities you want to support, you can think about what you want the charities to do with the assets that you're leaving them. It doesn't have to just go outright and unrestricted to a charity. You can talk to them about naming a specific program or purpose or area that's important to you. Maybe you would like to establish your own fund with the charity. I know at the University of Iowa, we get a lot of people that want to establish their own scholarship fund, for example. So that might be an option for you. And then finally, I would say if you are including charity in your plans, I would recommend you let your family members know that that's what you're intending. Explaining why a charity is important to you and why you want to include them in your plans, I think can go a long way to alleviating concerns of family members and to preventing hard feelings. I always think it's a really good idea to notify charity if you are including them in your estate plans. There's a number of reasons for that, and I think the first one here is really the most important, and that is that allows you to make sure that the charity is able to use the gift as you intend. I don't think anybody wants to make a gift to charity and have it sitting there at the charity not being used. That's not what you wanted, and that's not what the charity wants. But if you don't talk to the charity, you may designate it to a program that no longer exists, or you may restrict it in a way that is so narrowly restricted, the charity can't really use it for anything. So I think that just making sure you have that conversation with the charity allows you to make sure that what you want to do will work for the charity, and you can come up with a plan that works for everybody. Notifying the charity also allows you to make sure that you've got their correct legal name. A lot of times people think they know what the name of a charity is, but they don't. And so they will put an incorrect name in their estate planning documents. Just on Monday, I had an email from a trustee who said that they had a trust where the person had named the University of Iowa College of Veterinary Science as a beneficiary. And I had to write back and say, the University of Iowa does not have a College of Veterinary Science, nor has it ever had a College of Veterinary Science. And I suggested maybe the donor had really intended Iowa State University. But now that trustee has to try to figure out what the donor intended, and they've got a problem to deal with. So if you check in with the charity, you can make sure that you prevent all of that. The third point there, the charity is going to be very happy to thank you for your gift and to recognize you if that is what you want. So I would say charities want to keep their donors happy. And so if you communicate with a charity what you want from them in terms of recognition and communication and attention, they will be happy to honor your wishes. Some people, they want to be invited to events and they want to get letters and they want to get visits. Other people want no communication whatsoever. And so if you let the charity know what it is that you want, they will be happy to abide by your wishes. Finally, the last reason I would say for notifying a charity that you're including them in their plans is it gives you the opportunity to create a gift agreement if that's a good idea for your situation. So gift agreements, they go by different names. At my office, we call them a statement of gift intent. A lot of places call them a memorandum of understanding, but basically it's a document that a charity can prepare with you, and it allows you to put your exact wishes for your gift in writing, and it makes sure that the charity totally understands what you want to do and has agreed that they can handle the gift that way. So it gives you peace of mind that there is no ambiguity about what you want. You know what the charity is going to do with your gift. And it just makes sure that there's no misunderstandings. Another nice advantage of a gift agreement is it gives you some flexibility. If down the road, say you want to tweak the purpose that the charity is going to use with your gift, you can go back to the charity and create a new gift agreement without having to go back and change your underlying estate planning documents. So, you know, I've had some people that have changed their gift agreement half a dozen times in the years that I've worked with them. And that's fine. You know, we can do that. And yet they've never had to go back and change their will or their trust. And then finally, I've got a slide here with my email address and a picture of this estate planning organizer. So I have a few dozen of these organizers in my office. We had them printed up a number of years ago. And it's really a way for you to gather all of the information that you might want to take with you to an appointment with your estate planning attorney. So you can put all of your beneficiaries' contact information in there, all of your financial accounts and other information in there, life insurance, you know, all of that stuff can be sort of in one place. You can use it to take to your attorney, or some people just like to keep it with their estate documents because it lists all of their accounts and everything. I would be happy to mail one to you if you would like one. So my email address is up here. And if you just send me an email and give me your name and mailing address, I can pop one in the mail to you.
Thank you, Susan. I have had a chance to review that organizer, and it is a great resource, and it really holds your hand and guides you through everything that you need to have in place. So I would encourage you to reach out to Susan and ask for that resource. Excellent presentation. A couple things stood out to me, Susan, I'd just like to highlight is that, you know, I, a few months ago, finished my will, and I named my oldest daughter as the executor. She wasn't really thrilled with that, and I think that she would be really relieved to have me identify someone else. And I appreciate what you said about that, you know, really consider using a professional to guide the disbursement of the estate. And the other thing, the overall arching theme, I think, is to be sure that your wishes are documented and written down, so nothing is left to chance, and you know that the disbursement of your estate is going to be exactly what you hoped it would be. So thank you again for your presentation.
Thanks,
Michael, I'm going to turn it over to you.
Thank you. My name is Michael Lensing, and I'm a co-owner with at Lensing Funeral and Cremation Service in Iowa City. The one thing I guess I would say about the funeral director's role is it's very important because it really is the one person along with your family that can make those final wishes, even though they aren't wishes you want, but if you have specific desires, we make that happen. Part of us is to assist the family and designate them through this whole process, and hopefully really facilitate your wishes. The first thing we do, obviously, is bring the deceased into our care, and then also contact the family, the churches, or whoever they would like for services. But I think the main thing is for you to document what you desire. And our role is to really fulfill that as closely as possible. In some ways, we work closely with attorneys and allowing getting the Social Security notification taken care of, as well as providing death certificates that many times they'll need for insurance and different other financial documents. Many veterans have benefits that are available. For instance, burial at a national cemetery, if that's something they want. Or here in Iowa, for instance, there's the Iowa Veterans Cemetery down near Des Moines, which is beautiful and people use. So that's the basic thing that we do to facilitate and get things started. On the next slide, which will be up in a moment. Thank you so much. So I think the biggest thing is to really understand the many options that people have. And nowadays, I think it can get very confusing, even just talking about burial, cremation, or body donation, or tissue donation. So on the slide, we have burial with traditional burial, immediate burial, green burial. Traditional burial, I would say would be a very traditional service that somebody may wish, where we would do a preparation or embalming. They may have cemetery spaces at a local cemetery. And for some, it may be kind of the old-fashioned sort of service. It's not a celebration as life. It might be more like a funeral mass, or it be at a church, or be at a funeral home. For immediate burial, it would be more immediate, usually within 72 hours of death. The deceased is usually not embalmed. Most common, this would be those of different religious faiths or doctrines, such as Jewish families. We would not embalm. The deceased is buried in a wood casket with no metal and that sort of thing. Green burial is a little more natural. There are some cemeteries where there is a green burial section, but the main thing is that there is usually not a casket as such. The body may be wrapped, but it's a very natural process. And there are some of those throughout the country, but it can be done really in almost any cemetery. It's just different shades of green, to be quite honest with you. On cremation, I think cremation can be very confusing because people determine either they're going to be buried or cremated. Cremation doesn't mean that you can't have a funeral service with a body present prior to cremation. And we do that quite often, where there will be a service, a formal service, a visitation, if that's what they want, and it will be followed by a cremation. And then people may scatter the remains, they may bury the remains, they may divide them up. The interesting thing about scattering is that scattering can take place anywhere, except you are not to be doing it on public land or waterways. I'm sure it still happens, especially here at probably Kinnick Stadium. I'm sure we've had somebody do that a little bit off and on. They aren't supposed to, but that does happen. Cremation brings a lot more options available, especially for transporting if a death occurs away from home. Body donation, I think, also is very confusing. It used to be years ago that you could donate your body, for instance, to the University of Iowa Deeded Body Program, and it was used for medical students to study anatomically. But now, prior to that, you also have tissue donation, where before a funeral home would bring someone into their care, the donor networks throughout the country would remove tissue, they might remove bone and those sorts of things to be used in other items, or they could use it for research. If somebody's donating their body to science, the university, the research areas, they really want the body in its entirety. On the next slide, no, and prior to that, let me also mention too. So many people also will select a funeral home in pre-planning. Pre-planning is something that I would really advise for anybody. And I think it's not only just talking to your family and explaining your desires, but really letting them become a part of that. So they're the ones that have to deal with the loss of their loved one. And so how you proceed really affects how their whole life may be proceeding, to let them have some part of that. To select a funeral home, I would say, talk to a neighbor if they've had an experience, possibly previous family experiences, reputation of the funeral home. Also, as I've aged, I am not really big into Google, but I am surprised how many go onto Google and look at reviews. So I think just feel people out. All funeral homes will have a general price list because we're overseen by the Federal Trade Commission. But I would say don't base everything on the price. A lot of it has to do with the relationship you have with the person you meet and the trust you have had with that relationship and those people over the years. I would always recommend that families be present when sitting down with their loved one to plan their funeral. Pre-planning also means some people will write things on a pad at home and then stick it in a drawer and say, well, I've got everything taken care of, but that really doesn't work. It's really best to at least contact a funeral home if you've done that and maybe put something on file. So the first thing we do when we have a death occur is we go to our pre-arrangement files, and usually 50 to 60% of funerals that we do or services we provide throughout the year have been all written down, if not prepaid. Prepayment is an option. It may not be perfect for somebody that's 50 years old, but if somebody's 85 years old and they're going into a care facility and they're working with Susan or Bob to bring things together, that might be advantageous for them to do that. The main thing I would want people to know is that the money does not come to Lansing Funeral Home or any other funeral home, at least in Iowa. The money would go to, is placed in an insurance, form of insurance for pre-need. So the insurance company, for instance, here in Iowa, like Homesteaders out of Des Moines, holds that money until the death occurs, at which time we would file for that. The greatest thing about pre-planning is that it allows the family that they know they have fulfilled your wishes, that it's really they're doing what you wanted done. Very seldom have I ever had a family change from a pre-need that somebody's written down. Usually they always follow it very, very closely. On the next slide would be about death away from home. I think many times there's a lot of confusion. For instance, if a death occurs out of state, and let's say somebody's on vacation, God forbid, but a death occurs, what to do? And what I would suggest from my point of view is if you do have a relationship with a funeral home back in your home community, that would be your preferred funeral home. I would always suggest to families, and often do, to call back to that funeral home, talk to the person that you know and you've trusted over the years, let them help coordinate everything at the other end. I know we belong to a number of organizations where we have other funeral homes and funeral directors around the country. And many times I will call them and ask them to bring someone into their care so that they can forward them back to our funeral home. So there's different ways to do that, but basically we do that quite often. It's not as difficult as people think. If a death occurs outside the United States, the first thing we do is call the Department of State, which they always assist with this, and they're very, very good to families when a death's occurred away from home. But going back to the preferred funeral home, I would always highly suggest working through your local funeral home. I think it makes it easier for you, and they can interact with the other funeral home at the other end. Hopefully that gives some guidance, Pat.
Pat, you are muted, I'm afraid.
I am. Can you hear? I'm fine.
We can hear you fine, Michael. Thank you.
Good.
Thank you, Barb. Michael, you didn't speak specifically to this, but I was wondering about cemetery plots. Would the funeral director assist in securing, a burial site?
Yeah, so each town is different. And so, yes, we can do that. Usually the family, for ourselves, we'd have the family pay the cemetery directly, but different cemeteries have different, like for instance, here in Iowa City, there's city-owned cemeteries like Oakland. So we would set up an appointment for them to do that. The other thing also would be with cremation. Cremation, every funeral home in the country will provide cremation services, but not every funeral home has a crematory. And I guess this is kind of my personal feeling is that it's always nice to know that if you're seeking cremation, that many times it's nice to know if the funeral home has a crematory under their main roof. So that way it's like your loved one stays within their care. Now that's not always true at every place, but I think especially in larger markets, especially if you're working with a funeral home you aren't familiar, don't be afraid to really ask and find out. But the cemeteries, yes, we always help and we arrange that. Same way with clergy, celebrations of life, which have become really big. We also will assist with, maybe there's a facility that isn't related to the funeral home and it's something more upbeat, for instance, an outdoor farm or barn, that sort of thing.
Thank you, Michael. Thank you for that excellent presentation. And with that, I will turn it over to Bob.
Thank you. Thank you, Pat. Before I begin, I just wanted to mention that I've practiced my entire law career in Iowa City. And so a lot of what I talk about and speak about will have some Iowa flavor to it. So it's very important for you to speak with an attorney about your estate and your planning, and make sure that you contact an attorney in the state of your residence, because every law, almost every law is going to be different from state to state. And so you'll want to make sure everything complies with the laws of the state where you reside. So let's talk about the information for your survivors and what you should do and think about. I've had clients before when we've talked about what information to leave for their survivors. They'll can give a response that, well, I don't really care. I'm not going to be here. I'll let them deal with it. And that's not the way to deal with it. You need to think about what you're going to be putting your family through. And if you have a small business, what you're going to be putting your customers and your clients through. I know attorneys in Iowa now have to have a succession plan to handle their clients in case something happens to them unexpectedly. Some of the things that you'll want to put together have already been described, but the name of the attorney, where is your will, the original will, located? Where are your accounts? Where is your life insurance held? And who is the agent? I had a client who used to have a 3-ring binder, and she had all that information in there. And when she would leave on a long trip, she would pull it out and put it on her bed so that her family knew exactly where that information would be. You don't have to tell them how much is in the account or who is receiving it, but just the location of the information is very important. And some of the information may include, for instance, in your will, you may be giving bequests to certain family members, and they may be extended family members. But if you don't leave enough information how to contact them, you may run into the problem where your executor can't locate the beneficiary. And that has happened a couple of times over my law career. And then also the location of your assets. I had a situation once where the retirement company did not know that the retiree passed away. And it was a few years later that they determined that she did pass away. And then they were searching for the heirs. And it was by pure luck that they stumbled upon an obituary of a deceased sister of the retired person, that they were able to locate the actual beneficiaries and distribute a sizable sum of money to them. So it is very important to leave that information about the heirs and your assets for them. Also, digital assets. There may be some valuable assets, such as an account at a financial institution, but there also may be websites where you store photographs that the family values. You may want to make sure that you've checked with those sites to take whatever actions are necessary to allow people to log in after your death and obtain those photographs or work on within that site. And they will also need passwords and login information as well. And so you need to be prepared for that, especially with the world today. A lot less things are coming through the US mail and a lot more things are coming by email. It used to be that if I would have executors just watch the mail and look for a premium notice for a life insurance company, et cetera. But now that everything is by email, they'll need that information and permission to get into your email accounts and get that and gather that information. Now let's talk about the distribution of property and how that can be handled. So created a chart here about the assets that can be controlled and how that distribution happens. For instance, you may have an IRA, a 401k, some kind of retirement plan. You may also have a bank account or an investment account where you have a pay on death or transfer on death beneficiary. And the same thing with the life insurance policy, you have a named beneficiary. So those assets are not going to depend upon what your will says. Those assets will flow to the people you've designated or named as a beneficiary. And that, even though it may be reported in your estate with the court that you had that asset, it will flow directly from those companies to those beneficiaries. You need to be careful and constantly review your designated beneficiaries. I always tell my clients when they come in for a will appointment, look at your designated beneficiaries. Don't just assume that it's the people that you want to receive it. Some people have established life insurance policies before they got married. So you need to make sure that they have the appropriate designated beneficiary. Also, things may happen if you left, such as if you left an asset to your siblings. What happens if one predeceases you? Who is going to receive their share? Does it get divided among the remaining siblings, or does it go to the children of the deceased sibling? And what did you want to have happen? You may think that it's going to happen one way, but it's actually going to happen another. So you need to make sure that you know what will happen in those types of situations. And those will be automatic distributions. Those companies will be contacted by the beneficiaries, or they'll contact the beneficiary. The beneficiary will respond and fill out the appropriate forms, and then they'll receive the direct transfer of the asset. Joint ownership of assets works very similar. By operation of the ownership of the account or the ownership of the home will automatically transfer to the survivor. Sometimes you have to record a document to indicate that a person passed away and that it is now owned by the survivor, but that's just a technicality, but it actually automatically passes to the surviving joint owner. Now, a living trust is a trust that you set up while you were alive, and you put your assets in this trust, or the assets that you want governed by the trust, and then that asset will flow pursuant to that trust agreement. If you've left an asset out of that trust, then it will be handled either by the laws of intestacy of the state where you reside, or your will. And that's where we talk about estate administration. If you have an asset that doesn't have a joint owner, that doesn't have a named beneficiary, that isn't subject to a revocable or living trust, then you'll have an estate that will handle that asset. And it could be because of the laws of the state where you reside if you didn't have a will, or by your will if you did leave one. Now let's talk about revocable trusts here and explain what they are. A revocable trust is a document you sign and you set up today. You usually name yourself as the trustee, and you transfer the assets that you want subject to the trust into the name of the trust. For instance, if you owned a piece of real estate, you may transfer it to be owned by the trust. You have a bank account, a checking account, you may want to transfer it so that it's owned by the trust. And then you would continue to handle that trust asset as the trustee while you're alive. Now, then your trust agreement will provide who will be your successor trustee. In case you're unable to be the trustee or you pass away, the successor trustee would automatically take over and handle those assets pursuant to the trust agreement. And in that trust agreement, you will also have designations and terminology as to what you want to have happen with those assets upon your death, very similar to the terms that you would have in a will. And this may provide for faster distribution of assets, but there are still some things that need to be done with the trust, such as a publication of a notice for creditors, and that sort of thing. So it still takes some time, but it may be a little bit faster than having an estate with a will. You still need a will if you have a revocable trust, just in case you've accidentally left an asset that's not titled in the name of the trust. Then where does that asset go? How is that handled? Usually people sign what's called a pour-over will, which says that if I've left an asset outside of the trust, I want it to be deposited into the trust and handled pursuant to the trust documents. Now, if you don't have a revocable trust, then what happens to those assets depend upon whether you have a will or the laws of intestacy where you reside if you don't have a will. One advantage of a will is you are able to name a legal guardian. That's the person who's going to raise any minor children. You get to name who your executor will be and nominate them. And you have to remember, executors may charge a fee. And so when considering whether to name a family member or a financial institution, you may want to consider the costs of doing that. You can also instruct the executor how to distribute the assets, whether they're owned individually or just not owned by a trust or not owned jointly. And this can help speed up the process of settling your estate. If you die without a will, quite often the person handling your estate will have to go to court to get permission to do things, and you can give your executor certain powers in your will, which allows them to do things without having to go to court for permission all of the time. If you pass away without a will, the court will have to determine who is going to be the guardian for your minor children because you haven't nominated anybody. And the court will have to appoint the administrator of your estate because you have not nominated anybody to do that. And because your assets will pass based upon the state laws, who will actually inherit from you will depend upon the laws of the state where you die. And that varies from state to state. Now let's talk about some of the jobs of the executor administrator.
Now, Michael, Bob, I want to just interrupt and apologize that some of this information is not there. It may come with further clicks, so allow me to click along with you.
Okay, all right. You'll want to obtain an attorney, and you'll want to determine the fees going to be charged by the attorney. When I first started practicing, as it is now, the limit on attorney fees was 2% of the gross assets of the estate. When I first started practicing, quite often attorneys would say, my fee will be 2%. That has, I think, here, at least locally, changed to a practice where attorneys will charge hourly. I know that's the way I do things, and I think that's more popular with clients now. Now, roughly speaking, the duties of the administrator is to gather up the assets, pay off any debts or claims, then take whatever's left over and distribute those assets to the beneficiaries. If you are the designated executor, what you'll need to do is obtain the original will, and you need the original will to have that probated with the court. So it's important, if you have a will, to let your nominated executor know where the original will is at, whether it's in your safe deposit box or whether it's been left with your estate planning attorney. The executor or the administrator, if they died without a will be responsible for notifying heirs and beneficiaries, as well as the estate recovery program. In Iowa, if the decedent had received state assistance through a program such as Medicaid, the state has a claim or a possible claim against the assets of the estate. And so they need to be notified if they have a right to file a claim against the estate. The executor is also responsible for filing an inventory with the court. So they need to get the date of death values of all of the assets and file that with the court. Even if you were able, let's say you had a living trust and you're not within the court system, that is something you'll want to do, is determine the date of death value of assets, because when those beneficiaries want to sell that asset, whether in the near future or later on, they'll want to know what the basis is in that asset. And that quite often is based upon the value on the date of death when that beneficiary received it from the decedent. And so that information will be necessary for those people, those beneficiaries, to know. There will be inheritance tax or estate tax returns that need to be filed. As Susan mentioned, many estates will not be subject to the federal estate tax because the exemption amount is close to 13 million as it is. And if there's a spousal situation, that's double because of the portability of the exemption amount. However, the current federal law is exemption amount is due to expire at the end of 2025, and it goes back down to $5 million per person. So that is something you'll want to keep in tune to as we're going through the next few years when you hear about the federal estate tax exemption amount, whether Congress is going to extend a $13 million exemption or whether they're going to let that fall back down to something closer to 5 million. As far as states can have either an inheritance tax, an estate tax, both, but one state actually has both, or neither. Iowa has an inheritance tax, and an inheritance tax, the amount of tax is based upon your relationship to the decedent. In Iowa, spouses and children don't pay any inheritance tax. Brothers and sisters, nieces and nephews do pay an inheritance tax, and the amount depends upon roughly how closely they are related to the decedent. Iowa's inheritance tax is going away in 2025, so there will no longer be an inheritance tax here. You will also be responsible as an executor administrator for filing the decedent's final income tax return. So if they have been filing income tax returns, one last one has to be done for the decedent. And then the executor or administrator is also responsible for paying off any claims that get filed in the estate, file an income tax return for the estate, and then at that point, they're able to file a final report and distribute assets to the beneficiaries. Now, let me just briefly talk about some fees and costs. If you have to open an estate with the court system, you'll have to pay some court costs. And that is one thing that you might miss out on if you have a living trust or revocable trust and don't have to use the court system. There is some savings that you might be able to obtain by not having to go to court and save from not having any court costs to pay. However, you still will probably have to use an attorney. You'll probably still have to file inheritance or estate tax returns if those are necessary, because the living trust does not save you any taxes. Those are all of my comments. So thank you very much.
Thank you, Bob. Such great information and advice from you. So much appreciated. One thing that really stood out for me, I have prepared a listing of all my accounts and investments for, for my estate, but I didn't think about, how important it was for those logins and password information, and that will be on my to-do list, and now can appreciate how important that is, so that there's relatively easy access when that time comes. So with that,
you need to also make sure they have permission, and if the site has a portal that you can go into and fill out the information so they can have access to your emails, that sort of thing, that's what you need. Otherwise, you may need to leave the permission in your will, so that the executor, has permission to get into your emails, because there's federal laws that govern or could come into play as to who can access your emails and access your digital accounts.
Wow. Thank you. Thank you. And with that, Barb, I will turn it over to you and see what questions we may have.
Sure, we have a few, and we have about 8-9 minutes for that. Michael, I'm going to have a question for you first. So twofold. One of our attendees would like you to list the name of the organization that holds the funeral prepayment amounts. What organization is that again?
That holds the money.
Right.
So there's many different ones. I mean, it'd be like here in Iowa, the one that has been around for 100 years is Homesteader's Life. Each funeral home would work with different ones. Years ago, you could take them to a bank and put them into a trust, but because of taxation and stuff, that's why the insurance is used. But Homesteader's the one we work with. There's NGL, National Guardian Life. There's a lot of these companies, most of them are designed to only handle pre-arrangement funds.
Okay.
So, yeah.
Great. And then we did have a question about purchasing plots in advance, which I believe you can do, but perhaps.
For cemeteries, yes. So what you would do is contact the cemetery, just call them. And usually there's a sexton who would come out and set up an appointment, show you the locations, and they would take care of the payment in advance.
Great. Thank you so much.
Thank
So next, this is a question regarding your a will. So this might be either Bob or Susan, but can you make a bequest without changing or modifying your will? Or is that just a big no-no? Like, if you're going to make the change, you better make the change in the will.
Well, I think Susan mentioned during her presentation, make sure you get it in writing. If you want it to actually happen, get it in writing. I suppose it's possible if you had an account and you wanted part of that account to go to an individual, you could name them as a pay on death beneficiary without changing your will. But you're going to have to do something, and as Susan said, put it in writing.
Any other thoughts on that, Susan?
Yeah, I mean, I see people a lot of times just do the beneficiary designation, and a lot of times naming a charity as a beneficiary of an IRA or other retirement account, that's often the best asset to use anyway for charitable giving, because those assets are taxable if left to individuals, but the charity doesn't pay tax. And so that's one way you can include a charity or without having to go back and actually change your will. You just want to always make sure that if you work out a plan with your estate planning attorney, that you don't then go and make a bunch of changes to the plan without consulting them and perhaps, kind of mess up what the plan was.
Exactly. So, Bob, there have been a lot of questions submitted to us in advance as well as during this session about trusts. So there are many, many questions about trusts. And so, again, we want to reiterate, this is when you, as a participant in this, should contact your personal estate planner, your estate lawyer. But Bob, can you give people an idea, when should somebody establish a trust?
Well, quite often, if people have minor children, they may want to have a trust in their will to handle the situation where the parent or both parents pass away, and then the assets are held by a trustee for the benefit of the minor children until they reach an age they feel comfortable that the child or children can receive the assets. Another type of popular trust is the revocable or living trust, where people execute the document, transfer assets into the trust. There aren't any tax savings by doing this. The advantages are, you hopefully, if you've done it correctly, you've avoided going to court when you pass away, and maybe some attorney fees as well that are involved in going to court. The disadvantages are it's going to probably be more expensive to set up a trust now. It will take you more time because now you've got to take the time to have your assets titled in the name of the trust. And then you have to be vigilant for the rest of your life to make sure I don't accidentally open a CD in my name rather than in the name of the trust, or that the bank or the financial institution makes an error and they open it up in my name rather than the name of my trust. So you have to be vigilant through the years to make sure that everything that you want in the trust stays within the trust. So those are some of the drawbacks now of doing that now.
Got it. So what about recommendations for people on how to find a professional executor? You know, is this a matter of, should they talk to their lawyer first, talk to a bank? Thoughts on that?
I've had clients ask me for recommendations. And if they do bank at a place that has a trust department, that might be the first place for them to go. If they feel comfortable with that financial institution, they may go visit with their trust department. Also, other family members or friends, in case they've gone through this before.
So we have time for maybe just one more question, and there are lots of great questions here, and we apologize that we can't get to them all, but there are a number of questions about transferring or dealing with the inheritance of land or property, whether that is, you know, how do you handle that? So Bob, I'm going to throw that to you.
Well, you know, some people have asked about adding children, for instance, on title to real estate or things like that. And you have to be very careful about that because, number one, they received the basis you had in the asset. And if rather than leaving that to them in their will, they don't get that step up in basis. And so if you bought a piece of real estate and you've added children on title, then when you do pass away, they aren't going to receive that step up in basis, and you may have to pay a lot of income tax. Also, by having co-owners now on real estate, any liens against these children are now going to be liens against your property while you're alive. And so and that can happen. So you need to be very careful and talk with your legal counsel to make sure that what you plan to do makes sense.
Great. Well, I want to take the time to just thank all of our panelists here and Pat, our moderator, for this discussion. There are lots of things to consider with this. I think we see that from the questions. Again, we, the Tippie College of Business, want to reiterate to you to talk to a professional. So talk to your estate lawyer, talk to a funeral parlor, funeral home director. There are professionals out there that are, their professional training is in knowing what to do and how to help you in your situations. And every situation is different. We can't answer them all, but we do want to encourage you to contact a professional about your specific circumstance. Now, many of you have asked about the handouts. Susan, your email is very popular in the questions. Again, Susan's email is susan.hagan, Hagan, @foriowa.org, and she can send you that handy planner. But there is a digital version of it on our website, along with a number of other helpful handouts that our panelists have provided. In addition, when you get an email with the link for the video, you will also in that email have a link for all of those handouts. So they're going to come right into your inbox as part of the amazing customer service that the Tippie College of Business provides to you on a daily basis. So again, I want to thank you very much. Now, please, if you are still with us, when this webinar ends, a very short survey will pop up. We ask that you take the survey, give us an idea of how this went, what else you would like to hear from us. And again, thanks to our panelists, thanks to all of you, and as always, go Hawks. Thanks, everyone.
Thank you.